This is the recorded lecture for Chapter 3 of our textbook, Making Law. With the first two chapters of our textbook, we studied a good bit about legal philosophy, or at least a broad overview of it. Now, with Chapter 3, we're going to see how these philosophies have become part of American law. This is part 1 of 3 lectures on this chapter. It's quite a bit of material, and in between the parts, I want you to go and watch a video online that's going to sort of elaborate on it in a more entertaining fashion. So you'll have an opportunity to listen to one part of the lecture, then stop and go look at the video, and then come back and do the next part. So it's 3 parts, and what you're about to hear is just part 1. So just make sure that you listen to all 3 parts of the lecture on Chapter 3. There's instructions, more detailed instructions in the agenda for the week of March 20 through 26. So know that you can go there if what I just said didn't make complete sense to you. So let's move on with part 1 for Chapter 3. For this chapter, these are the lesson objectives that I have. These are just the things that I want you guys to accomplish after you've listened to the lecture and done the assignments for this class. So it should be your own personal objective of what you want to learn in the context of this particular chapter. I'd like you first to learn the 3 different types of law in America: common law, constitutional law, and legislation. I want you to be able to explain how each of those 3 types of law is made, how they can be changed, and how they're connected to one another. Then I'd like you to be able to explain what is meant by due process and the rule of law, and how each of those 2 things are connected with common law and constitutional law, or really all forms of law. I'd like you to be familiar with the constitutional amendments. I don't expect you to memorize them like that. I just want you to be familiar with them, and particularly the Bill of Rights, and then understand the relevance that those amendments, particularly the Bill of Rights, had with the ratification of the U.S. Constitution. So I guess you can see there's a good bit of history in this chapter for those of you who might happen to be history majors. I'd like you to be able to understand the concept of judicial review, including the Supreme Court decision Marbury versus Madison. I'd like you to be able to explain and give examples of when a judicial standard of review, which I'll explain what those are, when each one of those standards applies to issues of equal protection and issues of fundamental rights. That'll make more sense when we get to that part of the chapter. And last, I'd like for you to be able to define and explain and give examples of those concepts that are listed there at the bottom of the slide. So let's move on, and we'll start out with the 3 forms of law. First bullet point here. So there are 3 forms or types of law in our country: common law, statutory law, which is also known as legislation, and constitutional law. Each of these 3 forms has its own history and characteristics that set it apart from the others. But each form of law affects the others. They work together in a way. So as you're studying this chapter, you can use 3 guiding questions for each form of law. How is it made? How does it change? And how does it affect or connect with the other forms of law? So the first form we're going to talk about is common law. And I'm starting there because common law is really the oldest form of law that was practiced in the colonies and then in our nation. So common law is made up of the precedents that emerge from dispute resolution. So if you ask, how is common law made? That's your guiding question. Well, the answer is it's made by judges settling disputes with regular people. The disputes could be over property rights, over physical harm one person caused to another, or it could be over a contract that wasn't performed, or a divorce, or some type of family dispute. Even crimes were prosecuted with common law at first. So when a judge decides a case or resolves a dispute, that decision will become the precedent for all other disputes involving the same or similar facts. So you might think of it as like common law is like bottom up law, because it starts out with just a dispute between two regular people, and that a judge decides the outcome of that dispute. That outcome becomes the precedent for all other future disputes that involve the same or similar set of facts. And the collection of all those precedents that were set through dispute resolution kind of come together and form a body of law called the common law. And it will control the outcome of disputes that occur within that court's jurisdiction. So you ought now to ask, how does the judge decide what the outcome should be? Now, remember, we studied different types of decision making. That was when we were studying Weber's philosophy of decision making. So here's where that philosophy comes into play. The outcome of a dispute could be, and for a rather long time actually was, simply based on the whim of a judge. And that's often because the judge was the king or the ruler of the land and had no accountability to anyone for anything. So that would be considered substantive, irrational decision making. So it's like case by case. Judge is going to just do what he thinks is the right thing to do, and it doesn't necessarily predict how anything is going to be decided in any future case. So it doesn't work. It's just a completely inefficient, unhelpful way of making choices or deciding how to resolve disputes. It doesn't work. It offers no predictability. What does work, as Weber taught, is formal rational decision making. And that's what we have in the common law. Judges decide the just outcome of a dispute based upon long-held customs and traditions and economic practices in the community. So it's common law. It's based on commonly held traditions and customs, or you might call them societal norms. They are applied to disputes in a logical fashion by a trained legal expert. That's formal rational decision making. And the judge is deciding a case and setting a precedent, a rule that will be applied consistently to all future cases that involve the same or similar facts. That's what makes it predictable. It makes the outcome of disputes fairly predictable because you know what the rules are that will apply. So because it's intended to offer predictability, the common law doesn't change very much. So next question, how does it change for common law? The answer is generally that it doesn't. Law cannot offer predictability if it's changing all the time. So that's a legal principle known as stare decisis. I've got that printed on the screen, stare decisis. It's Latin for the phrase, let the decision stand. And that's the goal for common law, is to develop these customs and traditions so that there can be predictability and structure in order for a community. Okay, now I'm going to give you an example of how common law works in everyday life. Now, this is completely made up, but it makes the point, and I think it'll be helpful for you to see kind of how it all plays out. So here's my story. You can see a picture of land there on the screen here. So buyer Bob is moving to Greenwood, South Carolina, and you can imagine that that's the property he might buy. He's coming to start a new job. He has lived his whole life in Alberta, Canada, and he knows very little about American law. He wants to buy this property that you see on the screen. He's to build a house on here. So he has searched property sales, and he comes across seller Sam, who has this land here for sale, priced at about $10,000 an acre. Bob and Sam meet at the property. Bob looks at it, likes its location. Sam tells Bob that the property is already plotted and plumbed. Bob agrees to buy the property. They write up a contract, money is exchanged, and the deal is done. Buyer Bob then hires a contractor, and the contractor gets to work building Bob's house. The contractor then sends Bob a bill for his services, and the bill includes the cost of installing a septic system. Well, Bob is outraged. He said there shouldn't be a need for a septic system because the property was already plumbed before he bought it. To Bob, Plumbed meant that the property already had both water and sewer lines running to and from it. Well, the contractor showed Bob that was not the case. The property was only plumbed for water, not sewer. There were no sewer lines, so the contractor had to install a septic tank and a system for waste removal, and that costs a good bit of money. Well, Bob goes back to Sam and accuses Sam of lying to him. Sam explains that in South Carolina, plumbed only means water lines, not sewer lines. He didn't lie at all. Well, Bob isn't satisfied, so he sues Sam, and they go to court. The judge hears the testimony and decides the case based upon the precedent for real estate property transactions. It's called caveat emptor, which means buyer beware. The precedent or the rule is that the buyer of property has the responsibility of doing his or her own investigation and evaluation of the property before he or she buys it. The seller has no obligation to disclose any conditions of the property that could be discovered by the buyer's reasonable investigation. If Bob had looked more carefully at the lines running to the property, he would have seen there were only water lines, no sewer lines. So seller Sam wins the case based upon that precedent. He was under no obligation to tell Bob about the absence of sewer lines. Sam is not responsible for Bob's ignorance about the term plumbed. So in this way, the judge has applied the precedent of caveat emptor to a specific case to decide the outcome of a property dispute. The judge has applied common law. That rule, caveat emptor, is actually a common law principle that has existed for hundreds of years, and it applies commonly throughout America, not just South Carolina, though there are many exceptions now. This is why people normally hire independent inspectors when they investigate property before they buy a house. That's generally the practice now. Buyer beware, right? You have to do your own investigation. But I'm telling you this just as an example to show you how common law works and offers predictability. And I'm going to come back to my little example in just a second. So if you caught it a few minutes ago, I said that common law generally does not change. There are exceptions when common law does change. It's just really rare. Judges can overrule a common law precedent when that precedent stops working out to be fair. It's only going to happen really when a case is appealed. So it's not necessarily going to be your trial judge, the judge that first hears the dispute. They are not in the habit of overruling precedent. They'll rule consistently, but the aggrieved party, the person who loses their case, can appeal, and an appellate court, a higher court, can sometimes overrule a precedent when that precedent stops working out to be fair. And you heard an example of that when I was teaching about the case of Riggs versus Palmer, where the young man killed his grandfather and then stood to inherit the dead man's fortune. Well, in that case, the appellate court did not apply, or they actually overruled the precedent that a written will controls the distribution of the decedent's estate because it wasn't fair for a murderer to profit from his crime. Now, that case is a very rare exception where a court chose not to apply common law precedent. Normally, it will be applied in all similar situations. Judges may find distinctions or differences between the precedent and the specific situation that is presently before them and therefore decide the case differently. But that's just known as distinguishing precedent. It isn't overruling or changing the law. It's just a way of saying that the facts are different enough that the precedent simply doesn't apply. So back to my silly example here with buyer Bob and seller Sam. If Bob had asked Sam plainly, is the property plumbed for a county sewer line? And Sam had said yes. Then the precedent of caveat emptor would not apply. We would have a case of outright fraud. So Sam would have lied, right? That is fraud. And the precedent would be distinguished. So it wouldn't apply, and Bob would have won his dispute. other than those very rare situations where a higher court overrules precedent, there are some situations where common law changes because another form of law, legislation, changes it. So we'll learn about that form of law, legislation, a little bit later on in part 3. For now, you just need to know that sometimes common law is superseded by legislation. And that just means that the common law has been replaced by an act of elected representatives. You see that most easily with criminal law. Every state in the U.S. now has criminal statutes that decide what crimes are and what the punishment for them will be. These criminal statutes are very detailed and sometimes rather complex. They replaced the common law of crimes that had previously controlled the prosecution of crimes. Elected representatives wrote out the very detailed, precise definitions of crimes like murder or rape or theft in all their varying degrees. And now juries have to apply those statutes when they are deciding whether someone is guilty of the crime. That is just one connection between common law and another form of law, legislation. Legislation can supersede common law. So statutes can become the codification of the pre-existing common law, as with criminal law. That's what happened. It just replaced the common law. But as for constitutional law, you'll see in a minute that some of the principles found in our Constitution arose from common law tradition. I believe I mentioned a few minutes ago that common law is the earliest form of law in America. It has a very long history, going back before America even existed. It's longer than I can really cover in an introductory course. Most of the common laws that we have today in America grew out of English common law. So English common law developed from the feudal law system that was brought to England in 1066 with the Norman Conquest. So those of you who have studied your world history, Western civilization, you've probably heard of the Norman Conquest. Well, that's kind of when common law took hold in England. And English common law was really just custom and practice for hundreds of years. When I say custom and practice, I mean there was no formal written rules or precedents or case reports guiding judges at first. But eventually, judges did begin writing down their decisions, and they would attempt to justify their future decisions by reference to the customs and prior decisions or precedents that they had made or someone near them had made earlier. Reports of those specific cases were first written down and circulated around the time of King Henry II. And in 1188, King Henry II's Chief Justice, his name was Ranulph de Glanville, if I'm pronouncing that correctly, it may not be. Glanville wrote the first written summary and explanation of English common law and how it came to be from pre-Norman time to the common law system of that time. His summary is called A Treatise on the Laws and Customs of the Realm of England. It wasn't perfectly complete, but it was the first effort to entrench the common law in some written format. Remember, though, the concept of law predated the technology of writing or printing information, and most people were illiterate anyway. So law doesn't necessarily have to be written down in order to be valid. Pre-literate cultures had well-developed bodies of law before they could communicate through the written word. Just keep that in mind. But what we're going over here are just the first efforts to actually write down, to record what the common law was. The next effort to compile the common law occurred with the Magna Carta in 1215. So the Magna Carta is a document that was written by English barons. That's the nobility, the wealthy landowners of English society. And it was begrudgingly tolerated by kings. So you'll hear more about this in the video, but the specific king who was first made to sign the Magna Carta was King John. He was not a good guy. He liked to tax at his whim, and you'll hear more about him in the video. It's pretty entertaining. But the barons got together and made him sign the Magna Carta, this sort of agreement that set limits on what a king may do. And it established certain rights, such as the right to a jury trial, the right to proportionality and punishment, the privilege against self-incrimination. Now that should sound a little familiar to you, like maybe in the Constitution. But at the time, that was common law that the barons recorded in the Magna Carta and made King John sign. It wasn't a complete statement of common law, and it really didn't protect the common person. I mean, some of it did. There were a lot of rules. I've got a picture of the Magna Carta on your slide there. It's not readable. They just had this tiny little, I think it was lambskin. Anyway, they tried to record certain rules that would limit what the king could do. So it was really the first effort to record these. And at the time, they were common law principles of due process. You'll hear more about that than in the video, though. So the next effort, notable effort, to record the common law came with Sir Edward Coke that we talked about a little bit in the last chapter. This was in the late 1500s and early 1600s. So Coke strongly defended the common law that was recorded in the Magna Carta. He insisted that the Magna Carta continues to bind all future kings. And he took that even a step further and wrote that even commoners enjoy those due process rights and privileges. He interpreted the Magna Carta, defining the rights that it gave, and recorded the common law in a series of treatises. So the last step then in getting, or the last step that we're going to talk about, because again, I can't go over it all. There's too much to it. But the last step we're going to look at is with the treatises of William Blackstone. And this is where we're kind of moving from English common law to American common law. So Blackstone was a British man. He was writing in the 1760s. And if you know your colonial history, you know this is when the colonists were starting to think very seriously about their independence. Blackstone summarized English common law into 4 content-specific treatises. Like, I think one was criminal law, one was property law. I don't remember the others, but there were 4. And this was at a time, again, when the colonists were starting to consider making themselves an entirely separate nation. So he built on the principles of the Magna Carta and Coke's treatises. And Blackstone is actually still quoted by judges fairly frequently. Even I referred to some of his treatises in my own briefing. So it didn't go away just because it got old. It's still being used. But one other thing to note about Blackstone, I told you that we're going to be sort of applying some of our theories and philosophies. Well, Blackstone was a transcendental natural law theorist. I hope you remember that from chapter 1. He believed, and he asserted in his treatises, that laws come from God above, and man discerned them through the application of reason and legal discourse. And he wrote them all down for everyone to learn and understand and enjoy the benefits of. So let me just recap for a second. By looking at its history, you can see how common law principles were really more than just principles to resolve disputes, although largely they were just the resolution of disputes, but they came to be something a little more. Several rights that we know today as due process rights began as common law principles long before the Constitution was ever written. So you must know that due process didn't originate with the Constitution. It originated with common law. And that's one of the connections between the two forms of law. Common law predated constitutional law, and certain common law principles became constitutional principles. Okay, so that's the end of this part of my 3-part series on chapter 3. Now, what I want you to do is close out the lecture, and you can go back in the agenda for the week of March 20th through 26th. You'll see a link to a video that's called Magna Carta and the Constitution. And that's going to help you kind of see how the common law is connected to the Constitution and the kind of the way British common law made its way into American common law and kind of became the fabric of American society. I think it's about 20 minutes long, maybe 30 minutes long, but it's really important. Go in and watch it. I'm not looking over your shoulder to make sure you do it, but it will help you tremendously to watch that. You'll get to see in a more entertaining way how this all works together.